Get ready for one of the most insane landlord-tenant nightmares we've ever covered. Today's case features Sue Hoi Tan, who claims she rented a room from what she describes as an absolute psychopath who invaded her privacy, ransacked her belongings, and then physically attacked her, leaving scars on her neck. But that's just the beginning of this wild ride. The defendant, Ellen Ray, has a shocking history that will blow your mind. We're talking multiple lawsuits, criminal convictions for assault, and a pattern of systematically tormenting tenants that spans years. This isn't just about getting rent money back. This is about exposing a predatory landlord who's been running what appears to be a sophisticated scam operation. We've got scissors as weapons, strangulation allegations, illegal rent overcharges, hidden criminal records, and a surprise witness with her own horror story. The final verdict will leave you speechless. And the judge's reaction? She's absolutely savage. This case has everything: drama, legal bombshells, and justice served ice cold. Buckle up, because this courtroom breakdown is going to be intense. Hold up. We're already seeing massive red flags in Sue's testimony. She's describing what landlord-tenant lawyers call constructive eviction, where a landlord deliberately makes living conditions so unbearable that tenants are forced to flee. But here's what makes this case explosive. Sue mentioned triple damages right off the bat, which tells us she's done serious legal homework. Triple damages aren't just handed out for normal disputes. They're reserved for cases involving systematic fraud, harassment, or violations of specific tenant protection laws. The fact that Sue is confident enough to request treble damages suggests she has evidence of a pattern of illegal behavior. Notice how specific she's being about the timeline: constant harassment, trespassing, and ultimately physical assault. These aren't emotional outbursts. These are carefully chosen legal terms. Ellen's daily, frivolous demands about how Sue should arrange her own room already crossed the line from reasonable landlord concerns into harassment territory. In tenant law, landlords have no right to control how tenants organize their personal belongings in their private space. The moment Ellen started dictating pillow placement and demanding unpacking inspections, she violated Sue's fundamental right to quiet enjoyment of her rental. This testimony is building a textbook case of landlord harassment. 5. Whoa! Ellen just admitted to the most egregious privacy violation I've ever heard in a landlord-tenant case. She's casually describing entering Sue's private room without permission to conduct unpacking inspections. Folks, this is legally catastrophic for Ellen's defense. In virtually every jurisdiction in America, landlords must provide at least 24 hours written notice before entering a tenant space, and they need legitimate reasons like emergency repairs or pre-scheduled maintenance. Ellen's claiming she needed to inspect Sue's unpacking because of bugs. But that's not a recognized legal justification for warrantless entry. This goes way beyond normal landlord rights and ventures into stalking territory. Think about what Ellen is describing. She's monitoring Sue's daily activities, tracking her belongings, and conducting unauthorized searches of her personal space. This isn't property management. This is surveillance and control that would make most people feel unsafe in their own home. The legal principle of quiet enjoyment means tenants have the right to use their rented space without interference, monitoring, or micromanagement from landlords. Ellen's bug inspection excuse is so legally weak that it actually makes her violation worse. It shows she knew she needed some justification, but chose an obviously inadequate one. Any competent tenant rights attorney would have a field day with this admission. Ellen is digging herself into a massive legal hole with every word. She's describing obsessive-compulsive behavior that goes way beyond reasonable property management and enters the realm of psychological harassment. Listen to the level of detail she's providing about Sue's belongings. She knows exactly how many body wash bottles Sue had, whether they were half full, what was in every box. This isn't casual observation. This is systematic surveillance of someone's private possessions. In landlord-tenant law, there's a concept called reasonable use and enjoyment, which means tenants have the right to live normally without constant monitoring and interference. Ellen's fixation on empty boxes, her demands to reorganize Sue's cosmetics into specific containers, and her self-appointed role as the unpacking inspector are textbook examples of harassment designed to make tenants uncomfortable enough to leave. But here's the most legally damaging part. Ellen admits she helped by going through Sue's cash, valuables, and jewelry. That's not organization. That's potentially criminal invasion of privacy, and could even constitute theft, depending on what she moved or examined. Even with the best intentions, landlords cannot rifle through tenants' financial assets without explicit written permission. This single admission could be grounds for criminal charges, not just civil damages. The judge just asked the most important question in this entire case. How many roommates has Ellen cycled through? Ellen's answer of at least 6, maybe more, is absolutely devastating to her credibility. In legal proceedings, this establishes what attorneys call pattern evidence, or prior similar acts. When someone has repeated problems with multiple unrelated people, it strongly suggests the common denominator is them, not everyone else. Think about the statistical improbability here. If Ellen was a reasonable landlord, what are the odds that 6 different tenants would all turn out to be problematic? The legal principle is that past behavior is the best predictor of future behavior, and Ellen's admission reveals a clear pattern of failed housing relationships. But there's more damaging information buried in this exchange. Ellen is 57, unemployed, has had failed long-term relationships, and admits to having control issues around cleanliness. This psychological profile explains why she had so much time to obsessively monitor Sue's every move, and why she's financially desperate enough to engage in predatory practices to keep security deposits. The judge is building a comprehensive picture of someone who is fundamentally incompatible with sharing living space, and who uses controlling behavior to drive tenants away so she can keep their money. Now we're entering the most serious territory in this case: alleged criminal assault and battery. Sue's claim that Ellen strangled her and left scars transforms this from a civil landlord-tenant dispute into potential criminal behavior that could result in jail time. Notice the specific details Sue is providing. The scissors incident is a trigger. Ellen lunging at her, grabbing her throat with one hand while taking scissors with the other, and leaving nail marks that scarred her neck. In assault cases, this level of specificity and consistency is crucial for establishing credibility. The sequence of events Sue describes follows a classic escalation pattern. Ellen made increasingly controlling demands, trimming towel threads, followed Sue around asking threatening questions, then physically attacked when Sue refused to comply. This isn't a mutual altercation or self-defense scenario Sue is describing. This sounds like a predatory attack by someone with serious anger and control issues. The fact that Sue immediately called 911 adds enormous credibility to her claims, because false accusers rarely involve police immediately after alleged incidents. If Ellen really did put her hands around Sue's throat, hard enough to leave scarring, we're looking at assault and battery charges that could result in criminal conviction, not just civil damages. Game over for Ellen's credibility. Sue has an official police report filed under strangulation. This is the kind of evidence that can single-handedly win cases. When police respond to domestic violence or assault calls and create official reports, they establish government records that are extremely difficult to dispute in court. The fact that the police categorized this incident as strangulation rather than just dispute or harassment indicates they took Sue's injuries seriously enough to document them as potentially criminal assault. This police report serves multiple crucial legal functions. It proves Sue immediately reported the attack rather than fabricating it later. It establishes that her injuries were visible enough for police to document. And it creates an official timeline that Ellen can't dispute, even if no arrests were made at the scene, which often happens in domestic situations. The existence of this report is devastating evidence. Ellen now has to explain how Sue got neck injuries serious enough for police to file a strangulation report. And her story better be consistent with physical evidence and witness statements. The legal burden has completely shifted. Instead of Sue having to prove assault occurred, Ellen now has to prove it didn't occur, despite official police documentation. Plot twist of the century! Sue brought Danny as a witness, another victim of Ellen's systematic tenant abuse. This is the moment Ellen's entire defense strategy collapses, because now we're not talking about one disputed incident. We're looking at a pattern of predatory behavior spanning multiple victims over several years. Danny's story is absolutely shocking. She paid Ellen $5,200 up front and never got to move in. We're talking about a deposit plus 3 months' rent that Ellen just kept, refusing to allow Danny to move into housing she'd already paid for. But here's the legal bombshell. Danny has an actual court judgment against Ellen for this theft, proving Ellen's liability in a court of law. The fact that Ellen couldn't collect on the judgment because Ellen hid her assets and closed bank accounts reveals sophisticated debtor evasion tactics that suggest this is a systematic operation, not isolated incidents. When multiple unrelated people have nearly identical negative experiences with the same landlord, paying money up front, facing harassment and control, then being forced to leave while Ellen keeps their deposits, it establishes what lawyers call pattern evidence that can be devastating in court. Danny's presence transforms Sue's case from he said, she said, into multiple victims with documented evidence of systematic fraud. The courtroom just exploded with the revelation that Ellen has at least 7 additional victims with judgments against her, plus criminal convictions. We're not talking about isolated disputes anymore. We're looking at what appears to be a serial predator operation that's been victimizing tenants for years. The fact that Ellen has criminal convictions for assault and received community service means she's been found guilty beyond a reasonable doubt of violent behavior in the past. When someone has criminal convictions for assault and multiple civil judgments for the same type of behavior they're accused of in current litigation, their credibility is absolutely destroyed. Pattern evidence this extensive doesn't just support Sue's claims. It proves Ellen has a documented history of exactly the behavior Sue is describing. The legal principle here is that past conduct is admissible to show motive, opportunity, intent, preparation, plan, knowledge, identity, or absence of mistake. In other words, Ellen's history shows this wasn't an isolated incident, but part of her standard operating procedure. Harvey's commentary is spot on. If you have a history of problems, you're statistically likely to have problems again. Ellen's pattern isn't coincidence. It's evidence of systematic predatory behavior targeting vulnerable tenants. Danny's testimony about Ellen's extortion attempt is absolutely chilling and reveals the sophisticated nature of Ellen's scam operation. Picture this scenario. Danny has already paid $5,200 for deposits and advance rent. She's ready to move in on the agreed date. And suddenly, Ellen demands an additional $3,000 cash or she won't be allowed into housing she's already paid for. Ellen's justification? I need money because I've been unemployed for many years. This is textbook extortion under threat of housing denial. The police officer's immediate advice to not pay 1 more cent to this woman shows that even law enforcement recognized Ellen's behavior as criminal fraud. This wasn't a misunderstanding or legitimate fee. This was Ellen holding Danny's housing hostage for additional cash because she knew Danny was vulnerable and desperate. The fact that Danny called police and followed their advice to sue, resulting in the judgment we discussed, proves this was serious criminal behavior, not a civil dispute. Ellen's systematic approach is becoming clear. She targets people who need housing quickly, collects large upfront payments, then creates impossible conditions or additional demands that force tenants to flee while she keeps their money. This extortion attempt against Danny perfectly mirrors the harassment campaign against Sue. Both were designed to extract maximum money while providing minimal housing rights. Judge Milian just delivered one of the most savage judicial takedowns I've ever witnessed. Her systematic destruction of Ellen's credibility is both legally brilliant and absolutely brutal. One lawsuit could happen. Two might be coincidence. But 5 or 6 lawsuits about keeping tenants' money indicates systematic fraud. This statement captures the mathematical impossibility of Ellen being an innocent victim of multiple bad tenants. The judge is applying basic probability analysis. What are the statistical odds that 5 to 6 different, unrelated people would all be problematic tenants who broke agreements with the same landlord? It's astronomically unlikely, which means the common factor has to be Ellen's behavior, not the tenants. Judge Milian's observation that Ellen needs money and won't give back their deposits identifies the core motivation behind this systematic fraud. Ellen is financially desperate and using tenant abuse as an income source. The judge's recognition that Ellen sets impossible standards designed to fail, like requiring tenants to find their own replacements, exposes the sophisticated nature of this scam. These aren't legitimate lease requirements. They're deliberately impossible conditions designed to justify keeping deposits regardless of circumstances. This judicial analysis proves Ellen isn't just a difficult landlord. She's running a systematic fraud operation targeting vulnerable people who need housing. Holy moly! Judge Milian just delivered the most epic judicial smackdown in people's court history. I wouldn't live with you for 22 seconds. This is as close as a sitting judge can get to calling someone completely intolerable while maintaining professional decorum. But this isn't just a witty insult. It's a legal finding that Ellen's behavior violates fundamental tenant rights. The judge's systematic breakdown of tenant law is absolutely perfect. You don't have the right to walk into somebody's room and rearrange their undies. Captures the essence of Ellen's boundary violations in terms any viewer can understand. Judge Milian is explaining that when people pay rent, they're purchasing legal rights to privacy and quiet enjoyment of their space, not signing up to be micromanaged and controlled. Ellen's need for control is fundamentally incompatible with being a landlord because she cannot respect basic tenant rights to privacy in their rented space. The judge's recommendation that Ellen stop renting space because you don't know how to share is actually sound legal advice. People who cannot respect boundaries shouldn't be in positions where they control other people's housing. Ellen's response that 8 people agree with me, referring to the people who sued her, shows she still doesn't understand that multiple lawsuits prove she's the problem, not her tenants. Another legal bombshell. Sue discovered that Ellen is illegally overcharging rent in violation of New York housing stabilization laws. This adds a completely new dimension to Ellen's systematic fraud. She's not just harassing tenants and keeping deposits. She's also violating rent control laws to extract maximum money from day one. In rent-stabilized apartments, there are strict legal limits on what landlords can charge roommates, typically no more than 50% of the total rent. Ellen pays approximately $2,400 monthly rent, but was charging Sue significantly more than half that amount, which violates housing regulations designed to prevent tenant exploitation. Ellen's defensive attempts to justify the overcharge by claiming the room is furnished and includes utilities show she knows she was breaking the law, but hoped those amenities would provide legal cover. However, even with amenities, rent-stabilized apartments have absolute limits that cannot be exceeded, regardless of what's included. This illegal rent overcharge proves Ellen's operation is even more sophisticated than we initially thought. She's systematically violating multiple areas of housing law simultaneously. The judge's decision to include this illegal rent in Sue's damages is brilliant because it recognizes that Ellen was defrauding Sue from the very first day, not just at the end when she kept the deposits. The verdict is in. Judge Milian awards Sue $4,125 and delivers a legal finding that will haunt Ellen forever. This is systematic tormenting, designed to drive tenants away so Ellen can keep their money. This isn't just a monetary award. It's an official judicial determination that Ellen runs a predatory operation targeting vulnerable tenants. The judge's reasoning is legally brilliant and mathematically sound. With at least 8 documented victims following the same pattern, this can't be coincidence or misunderstandings. Ellen's business model is crystal clear. Advertise rooms, collect large upfront payments, then systematically harass tenants with impossible demands and boundary violations until they flee in desperation, allowing Ellen to keep their deposits, claiming breach of agreement. Judge Milian's award structure is perfect. She's giving Sue back her security deposit and last month's rent, the standard damages. But she's also awarding the illegal rent overcharge as additional compensation for the pure hell Ellen put her through. This sends a clear message that courts won't tolerate systematic tenant abuse, and that predatory landlords will face financial consequences beyond just returning stolen deposits. The $4,125 award represents complete victory for Sue and establishes legal precedent that Ellen's behavior constitutes systematic fraud, not legitimate landlord-tenant disputes. Ellen's post-verdict interview reveals the mindset of a predatory landlord who has zero accountability for her systematic abuse of tenants. Her claim that Judge Milian didn't get all the facts is absolutely delusional, considering Ellen has multiple criminal convictions, civil judgments, and at least 8 documented victims. Ellen is still trying to justify her behavior by claiming she was helping Sue by organizing her room. This shows she fundamentally doesn't understand that tenants have legal rights to privacy that landlords cannot violate, regardless of their intentions. The psychological disconnect here is staggering. Ellen genuinely believes she was being helpful by rifling through Sue's cash, jewelry, and personal belongings without permission. This isn't just legal ignorance. It's a complete inability to recognize other people's boundaries and rights. Ellen's continued victim-blaming mentality, "they were all students who found somebody else," reveals why she keeps victimizing people. She refuses to accept responsibility for her pattern of abuse and continues to rationalize predatory behavior as reasonable landlord practices. This interview proves that Ellen learned absolutely nothing from this legal defeat and will likely continue victimizing future tenants unless her predatory operation is completely shut down. Harvey's closing commentary captures the essential lesson that every viewer needs to understand. When roommate situations go bad, the solution is communication and reasonable exit planning, not harassment, assault, and systematic theft. Ellen's approach of tormenting tenants until they flee is not only illegal and immoral, it's ultimately self-destructive, because it generates lawsuits, criminal charges, and destroys any chance of legitimate rental income. The contrast between proper conflict resolution and Ellen's predatory tactics couldn't be more stark. Normal people sit down and work out problems or create exit strategies that protect everyone's interests. Ellen's systematic approach of harassment, privacy violations, impossible demands, and physical assault represents everything that's wrong with predatory landlord behavior. This case serves as a perfect example of how tenant protection laws exist specifically to prevent the kind of systematic abuse Ellen perpetuated against Sue and her other victims. The broader legal lesson is crucial. Tenants have enforceable rights to privacy, quiet enjoyment, and freedom from harassment. And courts will hold predatory landlords accountable when those rights are violated systematically. Sue's post-victory interview reveals something incredibly important about fighting predatory landlords. This case was never just about getting money back. It was about exposing systematic abuse and protecting future victims. Sue's statement that she came for justice and to expose Ellen's guilt shows the mindset needed to successfully challenge predatory behavior. Notice how thoroughly Sue prepared for this case. She researched housing laws, found other victims, documented violations, gathered evidence, and even hired advisory help to build the strongest possible case. This is exactly how tenants should approach predatory landlord situations, with comprehensive preparation, legal research, and determination to create a public record that will protect others. Sue's victory represents more than personal vindication. It establishes legal precedent, creates public awareness of Ellen's predatory tactics, and provides a roadmap for other victims to seek justice. The fact that Sue invested time and money into professional legal guidance shows she understood this was bigger than her individual case. Her research led to discovering the rent overcharge violations and Ellen's pattern of systematic fraud, which transformed a simple tenant dispute into a comprehensive exposé of predatory landlord operations. This case represents a masterclass in how tenant rights advocacy should work when facing systematic predatory behavior. Sue's approach: comprehensive documentation, legal research, pattern evidence gathering, and witness testimony, created an overwhelming case that completely destroyed Ellen's credibility and exposed years of systematic fraud. The legal lessons are crucial for anyone facing landlord harassment. Document everything in writing. Research your landlord's history through court records. Understand your local tenant protection laws. And don't be afraid to involve law enforcement when harassment escalates to physical threats or assault. Sue's discovery of Ellen's criminal history and multiple civil judgments proves the importance of background research. Predatory landlords often have patterns of abuse that can be documented through public records. The rent overcharge discovery shows why tenants need to understand local housing laws, especially in rent-controlled or rent-stabilized markets where violations can result in significant financial penalties. Most importantly, this case demonstrates that systematic predatory behavior can be successfully challenged in court when victims come prepared with evidence, witnesses, and comprehensive legal arguments. Before we wrap up this incredible case, let's talk about the warning signs that could help future tenants avoid predators like Ellen Ray. The red flags were there from the beginning: excessive control over personal belongings, demands for immediate unpacking inspections, obsessive focus on cleanliness that goes beyond reasonable standards, entering rented spaces without permission, and making tenants feel constantly monitored and uncomfortable. Ellen's financial desperation, unemployment, and history of failed relationships created the perfect storm for predatory behavior, targeting vulnerable people who need housing quickly. The pattern revealed in court: collecting large upfront payments, creating impossible living conditions through harassment and control, then keeping deposits when tenants flee, represents a sophisticated fraud operation that specifically targets people in vulnerable housing situations. Future tenants should always research potential landlords through court records. Verify rental amounts against local housing regulations. Document all interactions in writing, and trust their instincts when living situations feel controlling or unsafe. Most importantly, tenants should understand their legal rights to privacy, quiet enjoyment, and freedom from harassment. These aren't just courtesies. They're enforceable legal protections that courts will uphold when systematically violated. What an absolutely extraordinary case that exposed the dark reality of systematic predatory landlord behavior and showed how justice can prevail when victims fight back with preparation and determination. Let's recap the shocking revelations. Ellen Ray systematically terrorized at least 8 tenants through privacy violations, harassment, illegal rent overcharges, and even physical assault, all while running a sophisticated scam to keep security deposits and advance rent payments. Sue Hoy Tan's $4,125 victory represents far more than financial compensation. It's a judicial finding of systematic tormenting that validates every victim's experience and establishes legal precedent against predatory landlord operations. The key lessons from this case are invaluable. Document everything. Research your landlord's background. Understand local tenant protection laws. Don't tolerate harassment or privacy violations. And fight back with comprehensive evidence when your rights are systematically violated. Ellen's multiple criminal convictions, civil judgments, and pattern of fraud prove exactly why tenant protection laws exist and demonstrate that even the most sophisticated predatory operations can be exposed and defeated in court. Sue's approach: thorough preparation, legal research, witness testimony, and determination to seek justice beyond personal compensation, provides a perfect roadmap for other victims facing similar systematic abuse. This case proves that when tenants know their rights and fight back with evidence and preparation, even serial predators can be held accountable and stopped from victimizing others. If you found this case as shocking and educational as we did, make sure to hit that like button to support our legal breakdowns that expose injustice. Share your thoughts about predatory landlord experiences in the comments below. And don't forget to subscribe for more jaw-dropping courtroom analysis that celebrates when the system works to protect victims and hold predators accountable.